Hey there, welcome back to yet another episode in the journey of demystifying the Patents Act. In the last couple of episodes, we assisted our actor when the actor was faced with a situation where either a patent application was filed or a patent got granted pertaining to a technology, product, or services. And the actor was not thrilled about the development at all. This is how we envisioned the situation, and these are the options that we evaluated for opposing the grant of the patent. During the application phase, we went for pre-grant opposition as per section 25.1. However, after the grant of the patent, we went for post-grant opposition, but within the first year from the date of the grant. Now consider a situation where we have missed both these opportunities. What options do we have to oppose a granted patent? And most importantly, what platform do we have to oppose such a granted patent? In this video, we will go over the provisions available to us to oppose a granted patent. As per section 64, any person interested or central government can file a petition to revoke a patent anytime after the grant of the patent. But who do you approach? You don't approach controller with such petitions. You approach IPD, which is Intellectual Property Rights Division at High Court, which was set up once the IPAB was dissolved in the year 2021. You can also approach high courts directly in certain situations. We will discuss about those situations during the later slides. You may recall from our previous episodes, while filing such request or petition, you need to identify the grounds on which you intend to oppose the grant of the patent. Now, what are these grounds? Recall our discussion from the previous episodes. We took assistance from section 2 to 13 that defines various technical and procedural requirements for a patent application to be granted. We found discrepancies on the applicant's part and used those as our grounds for opposing the grant of the patent. Let's revisit all these technical and procedural requirements in a different manner this time around. Let's start with the initial sections, section 2 and 3. We can use the definition of section 2 to evaluate if the invention as claimed in the patent is novel, or was it published or used or known to the public before the priority date of the application, or if the invention has inventive step in light of the knowledge which is already available in the public domain. Think of the prior art documents which are used as per section 13, prior publications, or the Indian applications which were filed before the priority date of the patent and claiming the same invention. Is the invention useful as per section 2.1 AC? This was not one of the grounds for the pre or post grant opposition. Moving on, section 3. Can you prove if the subject matter as claimed in the patent belongs to one of those specified as per section 3, or the subject matter belongs to atomic energy which is not patentable as per section 4. But not all such prior usage or prior publication can be used as valid grounds for revocation. There are few exceptions also. Section 64.2 and section 64.3 provides such an exception. So prior publication by means of a personal document will not be considered as a valid ground, or any prior use only for secret trial or secret use or experimental purpose will not be considered as a valid ground for revocation. Similarly, use of the invention by or on behalf of the government will not be a valid ground. Further, if the invention was used by another person who obtained the invention from the patentee but used the invention without the consent of the patentee, such usage will not be considered as valid ground for revocation of the patent. Moving on to another ground which relates to who is the applicant for the patent application. We can evaluate if the applicant is entitled to file an application in India as per section 134, which deals with reciprocity of rights. If another country doesn't provide similar privileges to the Indian resident as they provide to their own citizen, then citizens of those countries are not entitled to file an application with the Indian Patent Office. Similarly, if the patent was wrongfully obtained or was obtained on false representation, we can evaluate the patentee or the applicant with these three requirements. Moving on to the next ground, which are related to the requirements from the specification as per section 10.5. Specification should sufficiently and fairly describe the invention, should also describe the best method of operation. In case of biological material, the source or origin should be provided accurately. With regards to claims, the claim should clearly define the scope of the invention and should be fairly based on the specification. In case specification was amended as per section 57 and 58, we can check if there was any fraud committed to obtain permission from the controller to make such amendments. Next, we'll identify the grounds which are related to the obligations imposed by the Patent Act on the applicant or patentee. As you may recall, foreign filing details need to be provided up to the grant of the patent in India. So we can check if such a requirement was met, if accurate information was provided to the patent office. Similarly, we can check if secrecy directions were followed by the patentee. The invention should not have been published, or the information pertaining to the invention should not have been communicated with any other person in India or outside India. Similarly, we can check if a patent application was filed outside India without obtaining prior permission from the patent office as per section 39. So we have discussed all possible grounds that can be used to oppose a granted patent. We can choose one or more of these grounds, substantiate them with appropriate evidence, and prepare our petition. Once the petition is prepared, we can approach the IPD with the petition. Upon receiving such a notice, IPD notifies the patentee or any other person who may be termed as interested in the patent as per the register kept at the patent office. Beyond this, the parties would provide statements, counter statements, evidences, responses. A hearing may be conducted, and thereafter a judgment may be provided by the IPD. Now, what that judgment could be? It could be either the petition is threshed or petition is accepted and the patent is revoked. Remember, we talked about approaching High Court also with such a request during certain situations. So what are those situations? In case an infringement proceeding is already going on at the High Court between the parties, in such cases, one of the party, basically the defendant, can file a counter claim for invalidation of the patent. In this case, the High Court will go over the submissions to decide whether the patent will be revoked or not. Moving on to the another party, the central government, that can also approach the High Court with a petition to revoke the patent on the grounds as mentioned earlier, or for the reason that the patentee has failed to make, use, or exercise the invention for the purpose of government as defined under section 99. Here also an opportunity could be provided to the patentee to provide their side of the story, and then the High Court will provide a judgment whether the patent needs to be revoked or not. Carrying on with the central government can provide a direction to a controller to revoke a patent as per section 65. If the central government is of the opinion that the invention pertains to atomic energy, which is not patentable as per section 4. Upon receiving such a direction, the controller will send a notice to the patentee and provide an opportunity of hearing to the patentee. Once the hearing is conducted, the controller will come up with a judgment to either revoke a patent or maintain a patent. In case the patent is maintained, then the controller will provide an opportunity to the patentee to amend the specification so as to overcome the objection as raised by the central government. So even though the central government has provided direction to the controller to revoke the patent is not revoked, but the patentee is provided with an option to amend the specification. Very interesting point. Remember this. We learned that the central government can approach the High Court, central government can approach the controller. Central government on their own also can revoke a patent as per section 66. If they are of the view that the invention as such is mischievous to the state or is prejudiced to the public as per section 3b. Here also, the central government may provide an opportunity of hearing to the patentee as per section 66. Once the hearing is conducted and the central government is still of the view that the invention is indeed prejudiced to the public, it can declare its decision in an official gazette, and thereafter the patent will be deemed to be revoked. With this, we have evaluated all the options available to us for objecting a grant of a patent. Pre-grant opposition, post-grant opposition and revocation as per section 64 to 66. In the next video, we will discuss options available with parties in case of an infringement dispute. So I'll see you in the next video. Till then, be good and take care.